interject?
Just to let you know, I was a Ford retiree in benefits, and when I met Glenn, he was a guy that I said a lot of people to. Okay, a lot of people to.
Battery's on the way.
Okay, batteries on the way. So, but you're going to really enjoy it. He's got a lot of good information for us, a lot that we don't know. That's the thing that we're trying to overcome here. Okay, Glenn, you're on.
Thank you, Jim.
Good luck.
I can wait. I can either speak very loud, which I can do because lawyers, that's one thing they know how to do. They know how to talk, right? But I can speak loud and I will wait for the battery. Oh,
I'll take care of it for you. I'll pass it up to you shortly.
okay, thank you. Yeah, so I'll start right now and then we'll get the battery when it comes back in. I want to make sure you get all of your questions answered, okay? So I'm going to go through a lot of information this evening. I appreciate you having me out. It's a beautiful venue, beautiful day to be out. And so my name is Glenn Matecun. As Janet said, my office is in Howell in that old historic McPherson mansion over there. Really nice place to work. I've been doing this for a long time, and I'll go into a little bit of my background. But today's roadmap, we want to talk about long-term care. If you ever end up in that situation, how you are going to avoid losing your home, losing your life savings. And then in order to prepare, you have to make sure that you have a basic estate plan in place. Thank you very much. Is that better?
Better.
Okay, go far. So, getting your basic estate plan in place, whether it's your will, your trust, your medical directives, your power of attorney. So we're going to talk about that in a little bit. This is what we hear when we talk to our clients and when we talk to groups like yours. There's a common thread when everybody thinks about estate planning and elder law, and that is uncertainty. And there are two sides of it. There's the estate planning side, like the wills and the trusts, and there's the elder law side. On the estate planning side, here's what I hear. I don't have an estate plan. So if you don't have an estate plan, there's going to be a lot of uncertainty. You don't have a will, you don't have a trust, you don't have a power of attorney, then what happens? You lose control. Sometimes we have people that come in and they have these big old binders. If you have an estate plan, you have a big old binder, they walk in, they drop it on my desk, and they say, hey, Glenn, I don't know what it means. I've never read it, I don't know, how to interpret it. So we look through a lot of those. And then one of the big ones that we're going to talk about tonight is I have an old estate plan. So your family changes, your money changes, your health changes, the law changes, taxes change. So we want to make sure we keep up with those changes so your plan works when you need it to work. So that's on the estate planning side. On the elder law side, it has to do with these numbers, 9939 and 119,268. Anybody want to hazard a guess as to what these mean? Any ideas?
Government.
Government, how about we put some dollar signs in front of them? $9,939 a month. That's the average cost of nursing home care in Michigan. It's over $119,000 a year. It doesn't matter if you have $100,000, $500,000, $1 million. If you start having to pay $120,000 a year for your long-term care, at some point you're going to run out of money. So we're going to talk a lot about how to protect those assets. A little bit about me. My law firm is called Matecun, Thomas & Olson. I am the Matecun part of it, although I have a daughter that is now an attorney at my firm, and she says she's the Matecun part of it. But for the time being, it's still me. I'm a certified elder law attorney. Okay, there's only 19 and now it's 18. Unfortunately, one of the certified elder law attorneys recently passed away, so there's 18 certified elder law attorneys in the state of Michigan. How many attorneys are there in the state of Michigan? Anybody want to guess? Paul would say too many, right? Too many. Too many. 35,000. 35,000 attorneys in the state of Michigan. 19, now 18 of us are certified by the National Elder Law Foundation to handle senior elder law matters. Okay? So I'm very proud. We had to go through a peer review. We had to go through a testing. It's almost like a second bar exam. So a lot of people hanging their shingles out there saying we do estate planning, we do elder law, but they aren't certified, and they also do your traffic tickets and their drunk drivings and all sorts of other things. That means they don't specialize in these areas. I'm accredited by the Department of Veterans Affairs, so if you work with senior veterans, you have to be accredited by the Department of Veterans Affairs, and I am. I'm the host of a small radio show, so every Sunday morning, there's something called Senior Law Radio on WHMI 93.5. If you get up, have a cup of coffee, feel free to listen. We're talking about the same types of things that we're talking about here this evening. And I have a couple books, and I'll show you these, and we give them away for free. One is called You're Not Alone Living with Dementia. One is called Living as an Alzheimer's Caregiver. I wrote these because there's a lot of scientific and kind of the gobbledygook legal stuff out there that doesn't make any sense. These are in plain language. If you want a copy, we give them away for free. I brought a handful of them tonight. Just make a note or stop and see me afterwards. And if you're dealing with a loved one that has dementia or Alzheimer's, let me know, and you're welcome to pick up a copy of the book. Okay? So that's a little bit about me, a little bit about my background, but that only tells you part of the story. My father was diagnosed with Parkinson's disease at a young age. And he battled Parkinson's for 17 years before he lost that battle. And so between my mother, my brother, and I, we walked every path of elder law, estate planning, nursing home rehabs, all of the things we're going to talk about this evening. So as we sit here and talk, I want to make sure you understand I know the law inside out. I've been doing this for a long time. But I also understand the family side because I've walked that path. And if you deal with legal things and you deal with family things, sometimes the family side of it is harder to deal with because you're dealing with different relationships between parents, between children. And so, again, when you're dealing with these things, you have to have a combination of legal expertise and almost like a social worker to deal with the family side. Okay, so that's a little bit about the background. Let's jump into why I'm here tonight. And everything that I deal with, you can really tag into 4 different levels. And I call them the estate planning and elder law pyramid. So incapacity, what do you deal with? Okay, so some people walk into my office and they want to know, well, I want to give my money in my house to my kids or to my husband, to my wife. First, we have to make sure that you're taken care of while you're here. Okay, so we're dealing with incapacity on the financial side and on the medical side. Who's going to pay your bills? Who's going to file your tax returns, open your mail? Do all of those things if you can't do them yourself. Who's going to take and work through your medical wishes? Okay, and each of you have different medical wishes. If you are in a difficult medical situation, you have to have somebody in place. Second level is long-term care. How are we going to deal with the long-term care situation if one arises? And you may all have been in or had a loved one in a long-term care situation. It's very difficult to deal with emotionally and financially, so we're going to talk about that. Wealth transfer. How do I get my money in my house, whatever else I have, to my loved ones in the easiest, most efficient, tax-friendly way possible? You don't want the government, you don't want the probate court taking a big bite out of what you have before it goes to your heirs. And then finally, beneficiary protection. Sometimes we want to leave something to someone, but they might not be able to handle it very well. Maybe they have creditors, maybe they have a disability, maybe they are in a bad marriage and you're worried about a spouse that is going to reach in and take an inheritance away from your son or your daughter. And so we'll talk a little bit about how to protect an inheritance for your beneficiaries if you decide to do that. So these are the 4 levels that we're going to talk about this evening. And we're going to do it. We're going to talk about Tom and Susan. They have a son and daughter, they have a house, they have a couple cars, they have a bank investment account, so they have some assets. They just retired. Tom worked for the city, Susan retired, worked for a business, and they have a couple kids. Anybody here have kids? A lot. Anybody here have more than 1 kid? I have 3. Are they all the same? No. No. So Tom and Susan have 2 kids. They have Beth and Ben. And my daughter saw this and said, hey, Dad, you're stereotyping. So today, Ben is the good guy. Ben is a Silicon Valley computer guy. He's doing really well. He's married. He's got a couple kids. Life is good for Ben, although he doesn't dress maybe how we would. On the other hand, Beth, she's having some trouble. Okay, she's got some traffic tickets. She's had some run-ins with the law, with the IRS. So while we love our kids the same, we might have to treat them differently for purposes of our estate plan. And so, what do you do when you retire? Tom and Susan, they made up a little to-do list. They're going to plan vacations. They're going to join a health club. They're going to create an estate plan. They hadn't got their will or their trust done. And they're going to do some volunteer work. All really, really good things to do, whether you're retired or not. What happens in my world? Okay, in my world as an estate planning attorney, what do people do when they have to go see a lawyer? They procrastinate. Okay, Tom and Susan procrastinated, and Tom was diagnosed with early stage Alzheimer's. And again, in my world, we would love to see people early on, okay, before they have any issues from a medical, health, emotional, whatever standpoint, okay? But what happens, again, if you've ever been in a medical situation where there's been a diagnosis of anything, the first thing there is shock, okay? You're getting through that emotional side. The second thing, in this case, is the one we see, is Tom and Susan sit down after the shock wears off, and they say, who's going to pay for long-term care if Tom ultimately needs long-term care? And what Tom and Susan find out is that, we're jumping to the second level of our pyramid, okay, we're going to go back down to that first level pretty soon. They find out that there's only 5 ways to pay for long-term care. You pay out of pocket. We have Medicare, which we're going to talk a little bit about tonight. There's something called a Veterans Aid and Attendance Benefit. We have long-term care insurance, which some people have, some people don't. We'll talk a little bit about that. And then there's Medicaid, which most people we talk to say they would never qualify for. And so we're going to talk about all of these and how they fit into your planning. And the first one we're going to talk about is paying out of pocket until you're broke. I will tell you, I've been doing this now 33 years or so. And nobody's ever walked into my office and said, hey Glenn, I want to pay for long-term care out of my pocket until I'm broke. Okay, so when I say there's 5 ways to pay for long-term care, this is only an option if you are relatively wealthy. Okay, if you have good savings. And we have clients that have saved enough to pay for long-term care. But most of the people we're dealing with are dealing with some other sort of benefit if they end up in that 9, 10. We had one last week that was in a $14,000 a month, and that's Wellbridge of Pinckney. It's $465 a day, $14,000 a month about, okay? So most people aren't paying out of pocket in that situation. So some people will come in and say, hey, Glenn, I have Medicare, okay, so I'm all taken care of. Is that true or false?
False.
False. Okay, Medicare is our over 65 health care program, and a couple of things about Medicare. Number one, it will pay for a very limited rehabilitation time in a hospital or in a rehab place. And generally speaking, it's covering 20 days. Okay, 20 days in rehab and up to an additional 80 days that will be paid with your supplemental insurance like Blue Cross or United, one of those. Now, when I say Medicare pays up to 100 days, has anybody ever had a loved one in rehab? Yeah, do they keep you there 100 days? They try to push you out the door, okay? And what we don't want, obviously, is when somebody's rehabbing, we don't want them pushed out the door because they need the rehab. Okay, so a couple things. There's something out there, and I very rarely talk about cases, okay, but there's a case called JIMMO, J-I-M-M-O. If you ever have a loved one in a rehab situation where they're getting pushed out the door, there was a settlement between Medicare and JIMMO back in 2013 that says they can't push you out the door if you're not progressing, if you're failing to improve. It's okay to stay in if you need the help to maintain or not slip back, not deteriorate. So what we tell people, and this is in your materials, if somebody you love is being pushed out of a nursing home, there's a self-help packet for appeal at MedicaidAdvocacy.org. And it's got a line-by-line appeal packet. It's a wonderful resource if a loved one is getting pushed out of the nursing home rehab, okay? So really what you need to know about Medicare is it will cover a very short period of time, but it's not a long-term care solution. So a lot of times while somebody's in rehab, we're doing the other things like veterans benefits and Medicaid, which we'll talk about in a couple minutes. So do we have veterans here? So very appreciative of your service. And for wartime veterans, there's a special benefit called aid and attendance. And it's a really good benefit, $2,600 a month, a little bit over. For a married veteran, single veteran, a little bit over, $2,200. The spouse of a deceased veteran, and yes, this is, so if a wife is in the service and the husband is the remaining spouse, the husband would have a potential right to benefit. If the husband is in the service and passed away, the wife is going to have the right to these benefits. There's 3 levels, okay, of these benefits, and I want to point out they're income tax free for life. Our government doesn't usually hand us a little, any money without taking a little piece of it, okay? But these are income tax free, so it's a really, really good benefit. There's 3 levels to this benefit. You have to be a wartime veteran. Wartime is World War II, Korean War, Vietnam War, and now we're even seeing Gulf War vets are starting to age into this benefit. So you do have to be a wartime veteran. You have to have certain medical conditions. So this is like a 3-step ladder. 1, you have to basically be in the service during a wartime. 2, you have to need certain medical help. And when they talk about activities of daily living, ADLs, does that ring a bell with anyone? So dressing and undressing and showering and bathing and bowel and bladder management and eating and transferring, with a wheelchair, walker, cane. So generally speaking, you need to have require assistance with 2 of the activities of daily living to get this veterans benefit. Okay? There's one exception, and one exception is if you have a cognitive disability like Alzheimer's, dementia, then you may be able to get it without needing help with 2 of the activities of daily living. So it's a difficult analysis sometimes, and so I'll tell you what we do about it in just a minute because I want to get to the 3rd level. 3rd level is financial, and that's where, again, we're dealing with the government, so they complicate it. There's income requirements, there's asset requirements. So what we have done as a law firm is we have a preliminary worksheet, and for any veteran or any of you who have a loved one who is a veteran, we complete it absolutely free. We do a report for you and send it back after you complete this preliminary workshop. And that report's going to say one of 3 things. You qualify, you don't qualify, or there's some questions as to whether you qualify or not, and we need to have some more information. So I brought a handful of those. So if you have a loved one who needs some care at home or in assisted living that's a veteran and you have not applied for these veteran benefits yet, you should grab one of those before you leave, fill it out, and we'll do a free report for you.
So if you're a veteran and you're already at a certain percentage disability, does that automatically qualify?
So that's a great question. So there's 2 types of veterans benefits. One are called non-service connected benefits. That's what this is. So for example, if you were in the wartime, it doesn't matter if whatever illness you have is connected to your service, so it's non-service connected. If you are rated, you will see veterans who are rated 10%, 20%, 50%, 100%. That's called service connected. So if somebody was working on jet engines, for example, and has a hearing disability, then they have a 10% or a 20% disability, they get a check every month. You can only have service connected or non-service connected. You cannot have both. So if this is more than your service connected and you need it, then you would apply for this. But the more you're rated, the higher you're going to get paid on a service connected. It'll be more than this.
Because I'm rated 50% right now.
Right. And I won't ask what that check is, but it's, you know, it's gonna be somewhere in that area, maybe a little less, I don't know. And so, you know, the fully 100% service connected, you never want to get rid of because you don't pay real estate taxes. There's some other benefits in that circumstances. But if you are partially, you know, rated something less than 100%, then ultimately, you know, you have to make a decision at some point.
I found out today that if you were in the service after Korea and before Vietnam, you are not a wartime veteran.
So he said he found out today if you were in the service after Korea and before Vietnam, that you are not a wartime veteran. And they have very specific dates. You can imagine our government has specific dates. And if you're in, you're in, and if you're out, you're out. So yes, you are correct. And if anybody has a question about their dates, they can write them down and submit it to us, and we'll let you know whether those dates are considered wartime or not. The other thing I'll point out on the service-connected side, if you are rated over 50% service, or I'm sorry, over 70% service-connected, then you get free long-term care through the veterans if you ever need long-term care. And so there's a benefit to try to keep pushing your rating up at least to 70%, so you can get free long-term care if you ever need it. Okay?
And the 30%, your meds are free.
Yes, and there are other medication programs. So you said at 30% the meds are free. There are also some other medication programs that the veterans have. We don't usually deal with those. We'll send you right to Ramon over at the VA to talk to. Okay. So that's the veterans benefit side of it. Again, if you have a loved one in that situation, grab a preliminary worksheet from us, fill it out, and we'll be glad to get that report back to you within about 7 days. Long-term care insurance. Most people don't have it, but those who do have one of two types. There's a traditional type, and there is a hybrid type, or what they call an asset-based type. Traditional type is use it or lose it, and it is a premium that you pay annually, sometimes semi-annually, quarter-annually, monthly, whatever you're paying it. What is the problem with this type of policy? The premiums go up, right? And we've seen people, yes, we've seen people with over 100% premium increases, and we've recently seen situations where they're threatening to push those premiums even further. So I'm sitting in my office with an 85, 87-year-old who said, you know, these benefits paid for him for 20, 25 years, and all of a sudden the premiums are doubling. What do? Do you keep paying it? You know, we do an analysis and we try to figure out the best scenario. So the other option is an asset-based or a hybrid policy where you come up with a lump of money up front, $100,000, $200,000, and they will pay for long-term care for a period of time. And you do have to pay a premium with that, but that benefit here is the premiums are guaranteed to never go up. So I think these policies have been marketed really, really poorly by the financial industry, okay? Because people don't understand them, number one, and number two, every time I ask somebody if they have this, they say, well, it's too expensive, so I can't afford it. I would tell you, if you are in a situation where you can at least consider it, look at it, and educate yourself on whether it makes sense, because if you do end up in a long-term care situation, it can take a really, really big bite out of your life savings, okay?
Is there any chance of those insurance companies going bankrupt because of the expense of the service?
Yes. So is there any chance of some of these insurance companies going bankrupt because of the cost of these services? If you have long-term care insurance, you probably have seen that there's been a whole bunch of mergers in the industry, and there's only a handful of companies left that are doing this. And again, there's a particular one that I know you are aware of that is, you know, there was some background things that went on with it, and we're not even sure they're going to have enough money to pay claims. So
The name of that company is January.
that's Genworth. I wasn't going to say it, but Paul said it, so I'll say it. So yeah, they're having some financial problems based on a lot of different things. But bottom line is, if you have a policy, you probably should have it reviewed. We always tell you once a year to at least call your company, find out what your benefit is, because most of them have an inflation, I call them an inflation kicker, so the numbers are gonna go up every year on some policies. So find out what your policy is, and then, you know, again, premiums. You know every year what your premium's gonna be, but recently we've seen them go really, really high. So again, most people don't have these. If you don't have one, I would at least look into it if you can to find out if it's an option for your specific situation. So what does that leave us with? If we can't pay out of pocket, Medicare is going to cover partial, you know, some of it. We don't get veterans benefits, or the veterans benefits aren't enough to pay, and we don't have long-term care insurance, that leaves us with Medicaid. And when we talk to our clients about Medicaid, here's what I hear. Well, if I get Medicaid, I'm going to lose my home. Does anybody ever hear that? Yeah, we hear that. I need to spend everything first. Yes? And we hear that when we sit down with clients and talk about nursing home care. If I give away assets within 5 years, I'm disqualified by Medicaid. Anybody ever hear that? So we hear this all the time. Every one of those things is 100% false if you plan the right way. So if you walk into a long-term care facility, they are not going to advocate for you and tell you how to protect your assets. I liken Medicaid a little bit to the IRS. So let's say I am filing my tax return this year and I don't take any deductions at all, and I send them in a big check. Is the IRS going to pick up the phone and call me and say, hey Glenn, you wrote too big of a check? No, they're not. Well, if you go sit down in a nursing home, they're not going to tell you how to protect your assets, because that's not their job. Okay, that's not their job. So I don't have time to go through all of the planning strategies in a Medicaid situation, but here's what we can do. For a married couple, we can protect your home and 100% of your assets if one spouse is in the nursing home. And so in Tom and Susan's situation, Susan could pay $10,000 a month for 5 years to have Tom in a nursing home if his Alzheimer's deteriorated and he couldn't stay at home anymore. However, we could take her $650,000 and we could put it in a special type of trust, and we can protect it under Michigan law. Why can we do that? Because Medicaid, just like the IRS, has deductions, exemptions, and more sophisticated planning. Medicaid has deductions, exemptions, and more sophisticated planning. So Medicaid has said, look, if Tom has to go into long-term care in a nursing home, we don't want to break Susan. Now we have 2 people that are on Medicaid. So we're going to let Susan take and protect her life savings. And they do it by, or we do it by, a specific type of trust. There's also a specific financial product there that we can use depending on the type of asset. So it becomes very complicated because people have homes, they have vacation homes, they have retirement accounts, they have non-retirement accounts, and there's a different way to protect each type of account in the state of Michigan. So Medicaid's a federal law, but it's governed by the state, and the states all have their own little tweaks to it. So Michigan law is different than Florida law, is different than Arizona law, but they're all similar, not identical. Okay? So, married couple, what you really need to take away from this is if you have a loved one in a nursing home and it's a married couple situation, we can protect 100% of your life savings. Single person, because we don't have that policy anymore, the government's not saying, hey, we don't want to break the spouse. They do allow us some deductions and exemptions, and so normally we can protect about 50 to 75% of a single person's life savings. And we do that by, there's ways, you might have heard of a Medicaid spend down. So there's ways to spend down. There's even certain gifting that is allowed in a Medicaid situation that you wouldn't think would be allowed. So when it comes to long-term care, you have to understand your situation. You have to educate yourself so you're put in the best position to make good decisions for not only yourself, but your spouse, your kids, your family. And what we see sometimes is Susan coming in 3 or 4 years later after Tom has been receiving care outside the home, and she says, I'm down to $50,000, what do I do? My answer is I really wish you would have come in a few years ago because we would have been able to protect it all. So if you have a loved one in a long-term care situation, please sit down with a knowledgeable person and talk about it so at least you understand the options before you start making decisions or not making decisions.
Okay, so we're actually residents of Florida, but we have property here too in our will and trust. We're all made up here. How does that work?
So the question is, I'm a resident of Florida, but I have property here. Technically, your plan would have to be updated here if you're going to update your plan here. If you went into long-term care here, then you would ultimately be a resident here. Okay, so even if you're a resident in Michigan, somebody who moves into a nursing home Florida, even somebody who moves into a nursing home in Michigan would be considered a Michigan resident because they don't necessarily determine your residency by your driver's license. It's where you are and where you intend to stay. So that's your residency. And so we just moved a client's mother up from Florida to a nursing home in Michigan, and we applied for Medicaid in Michigan, even though her driver's license and everything says she's a Florida resident. But again, if you're going to update your plan, you have to have an attorney licensed in the state where you're a resident. So you would have to have it updated in Florida.
Are you duly rated?
I am not duly rated. Florida is really difficult because they know a bunch of old lawyers are going to go hang their shingles down there and try to make a living, and they don't want a bunch of people doing that. So they make everybody take the bar down there if they want to practice in Florida. Okay. All right, so Medicaid, we can protect a lot more than you may think. So keep that in mind as you go through, and again, things happen in your life. Okay? So action steps for Tom and Susan. Get their foundational plan in order. So all of these protections, whether it's veterans, whether it's Medicaid, you have to restructure assets. And you cannot do it if you don't have a foundational plan. And I'll talk to you about what a foundational plan is. That's your will, your trust, your power of attorney, your medical directives, those types of things. But Tom and Susan have to get their base plan in order. Okay, so this moves us back down to the bottom level of our pyramid. Am I standing like right in your way? She's got to look at me the whole time instead of the screen. That's the problem. So anyway, we're back in incapacity. Okay, you can handle your affairs now, but there could come a time where you can't handle your affairs, whether they're financial or they're medical. So what do you have to do? In Michigan, we have what's called a financial durable power of attorney. And the biggest thing I can tell you is not all financial durable powers of attorney are created equally, okay? And I'm willing to bet that the 50% of you or more in here that have a financial durable power of attorney, it won't work the way you need it to work when you need it the most. Two things. There was a major law change in 2012, so if you have an old power of attorney, it will not work the way you want it to work. And number two, your power of attorney has to have long-term care specific provisions. We call them extraordinary provisions in it, so that we can protect assets if you're ever in a difficult situation. So if we're in that difficult situation I talked about with Tom and Susan, we have to create that special type of trust. Is Tom going to be able to come into my office and sit down and create a trust? No. Tom's in a nursing home, likely at that point with advanced dementia, advanced stage of Alzheimer's. So who's coming in? Susan's coming in. Okay, if Susan's not here, Tom and Susan's kids are coming in. So you have to have a really, really good power of attorney to allow the people you put in charge to do the planning that we're talking about, okay? So, from a financial side, like I said, all of your powers of attorney are out there, but we see powers of attorney that are done by an estate, so estate planning attorneys are more worried about, let's avoid probate. That's the only thing that they're worried about. And I'm an estate planning attorney. I do that too. Elder law attorneys are worried about, let's avoid probate, but also let's put you in the best position to protect your home and your life savings if you ever end up in a long-term care crisis. So we offer, and some of you I know have taken me up on it, we review estate plans at no charge. So if you have your big old binder with 500 pages in it, you've never read it, I've read it. because that's what I do, okay? So you can bring it in, I will look at it, I will tell you if it's up to date. You will tell me if it works for your family, you'll tell me if it works for your money, you'll tell me if it works for your health situation, but I will tell you whether it's up to date from a legal standpoint and whether you need to do something else to put yourself in a position to protect if you need to protect, okay? So keep that in mind. We do it all the time for people. Some people come in, we look at their plans, they're perfectly fine, we send them on their way. Some people come in and they need a tweak, and then some people come in and they have a guardian for their 12-year-old child in their will, and their child's now 62. Now we need to update their plan, okay? So if you haven't had your plan looked at in a little while, or if you haven't had it looked at by a specialist, have it reviewed to make sure it meets with the long-term care extraordinary provisions and the new rules in 2012. What about the medical side? A lot of people come in and say, hey Glenn, I've got that taken care of, I filled out the advance directive that the hospital gave me, and that's fine, they work. What I will tell you is this: the biggest issue we have is not people doing a patient advocate. Okay, in Michigan it's called a patient advocate designation. You probably heard it called medical directives or advanced directives or a healthcare power of attorney. They're all the same thing. Patient advocate designation is the legal technical name for it, and all that is putting somebody in place to help you carry out your wishes from a medical standpoint if you can't do it yourself. And I want to focus on that for 1 second, because some people will say, yeah, that's the thing where somebody's going to make decisions for me. I don't want somebody making a decision for you. I want them carrying out your wishes. There's a big difference. There's a big difference. And so a real bad day in our office, and we had one in the past month, we had a daughter of a client call us and said, I'm my mom's patient advocate, and mom's in intensive care in Ann Arbor, and she's unresponsive, and I don't know what she wants. And I always talk to my clients and tell them, sit down with your loved ones and tell them, if I'm ever in a coma or vegetative state, if I'm ever in a life-ending situation, what do you want? And since we're in a Catholic church, the diocese has a very specific directive that you can have. And you can review that and determine whether that fits your wishes or not. But again, you may all have patient advocate designations, but please talk to your next in charge about what you want or what you don't want, because you can't imagine, and you may have been in this situation, you can't imagine the emotional baggage, the emotional scarring of making a decision for a loved one when you don't know what they want. Okay?
Does it have to be written down?
So 2 things. We have it in ours. It is written down in ours. But I'll tell you there's a big difference between, and I'll use your son or daughter, it could be anybody else, but your son or daughter seeing it in writing is different than them hearing it from your lips, okay? They can say, yeah, I talked to mom about that, I talked to dad about that, and so I know what they want. They read it in the paper, they're gonna say, well, you know, they didn't want to be kept alive on a machine forever and ever. I get that, it's in the paper, but having talked to them about it, I think gives you another level of them carrying out your wishes and making sure they're doing what you want and not necessarily what they think you would want under the circumstances, okay? So yes, some people, and you can write down as much as you want. So a lot of people will go the extra step and fill out some, some different, there's something out there called the 5 wishes, and the 5 wishes has a kind of a long explanation of what I want in certain situations, okay? And you can go to that extent if you choose to do that. But the more in writing, the better, but I still think you should talk to your loved ones about what you want. The other thing on the medical side, which is different than the patient advocate, is HIPAA. Is everybody familiar with HIPAA? So the Federal Privacy Act. So if you're lying in the hospital, I walked into the hospital and started asking questions, they're going to say, hey Glenn, it's none of your business, get out. Okay, but they'll do that to your kids. They'll do that to your siblings. They'll do that to your loved ones. So, for example, I have a wife. I've been married now 35 years. I have 3 kids. My wife would be in charge. So if I'm lying in the hospital, my wife's in charge under the patient advocate, But under the HIPAA authorization, my 3 kids can walk in and say to the doctor, hey, how's dad doing? And the doctors can talk to my 3 kids because they're not authorized to talk to them under the first thing, under the patient advocate. So HIPAA is going to give us a much broader coverage than the patient advocate designation. So you should have a self-standing HIPAA authorization on top of your patient advocate designation. Okay? So what happens if you do not have these things? And I use this picture and I feel really bad because Judge Miriam Kavanaugh is our judge here and she looks nothing like this old crusty judge. And she's very nice and does a very good job. But you get a living probate. Okay, living probate, everybody thinks, well, probate's after you're gone. Well, if you're here and you don't have your power of attorney, your medical directives, you have to have a conservatorship for the money, you have to have a guardianship for placement decisions and medical decisions, and if you don't have these things, then you're basically in front of a judge, the judge is putting somebody in charge, you have to report to the court for the rest of your life, whether it's on your healthcare side or under the financial side. And so it's emotionally draining, it's expensive. You're dealing with, again, no offense to my brother attorneys, but you're dealing with lawyers, okay? Most people I meet, they say I want to deal with as few lawyers as I possibly can, okay? And if you're in a living probate, you are dealing with the court, you're dealing with the government, you're dealing with lawyers, and you don't want to do that because you can handle it up front, okay? All right, let us jump up to wealth transfer. We talked about incapacity, we talked about the long-term care side of it. How do we get our assets where we want them to go in the easiest, most efficient, tax-friendly way possible? Not the government taking a bite out of it, not the probate court taking a big bite out of it. And this is where most people say, hey Glenn, do I need a will or do I need a trust? And I'm not sure, and nobody's ever explained it in terms that I can understand. So what do I do? Okay, and some people come in with a trust and I still don't understand it. And some people come in with a will and say, I have a will and I've been told I'm going to avoid probate. Well, the biggest difference between a will and a trust, a will goes through probate, a trust does not. Okay, what is probate? I call it the state's big rule book. Okay, so if you die with a will or without a will, then the state's going to be in charge of putting, they used to call it the executor, now they call it the personal representative. So somebody's got to be put in charge and then your assets are going to be distributed per your will, and if you don't have a will, then per the state of Michigan rules. Okay? So what is probate? I'll use Paul because I know Paul. Paul, where do you go shopping? Where do you do your grocery shopping?
Kroger.
Kroger. So Paul pulls into Kroger and he steps out of his car, he starts to walk in. And what do you usually do when you walk into Kroger before you walk in the store, or as you're walking in? You grab a cart. Now Paul's Superman. He doesn't need a cart, okay? All right? Paul's getting his milk and his eggs and his meat and his potatoes. He's got it all layered over him, carried on his shoulders. And he's walking down aisle 3 and he hits a wet spot. What happens?
Yes,
Yeah, that's probate court, okay? That's probate court, okay? Clean up on aisle 3, and the judge is the clerk, and the judge is basically gathering everything back together and saying, here's who's in charge and here's where it goes, okay? So, what's a trust? Trust is just like a shopping cart, okay? So Paul's walking down the aisle, he's got his meat and his potatoes and his eggs, he's got it all in the shopping cart, he hits the wet spot, falls down, where is everything? It's in the cart. It's in the cart, and that's what a trust is. A trust is basically a gathering place for your assets. They are all there, okay? And they can be there because you put them there, or they can be there because you named the trust a beneficiary of, let's say, life insurance or a bank account. But at some point, they're going into your shopping cart. And if you slip and fall down, or if you're gone, you name somebody else to push your shopping cart. That's called a successor trustee. And that successor trustee continues to push your shopping cart, reads your rules. Your rules are going to say something like this. If I'm gone, pay my final expenses and divide my money among my children. Okay? That's going to be on the side of the shopping cart. Okay? So what is a trust? Trust is your rule book. So if you go through probate, You're at the mercy of the government, the judge, the timing of everything going on. The trust is your rule book, putting everything together so that you're not gonna have a judge, you're not gonna have delays in distributing things or selling the house or whatever needs to be done, okay? So when we do wealth transfer, when we sit down with clients, we want to make sure things go in the easiest, most efficient, tax-friendly way possible. Many times that's a trust, but other times we can get away with something a little simpler. So all of you probably have beneficiary designations on something, whether it's life insurance, whether it's an IRA, 401k, those types of things. So you'll see beneficiaries called something, POD is pay on death, TOD, transfer on death, ITF, in trust for, just all names for beneficiary designations. I can tell you this, kind of like the power of attorney, over 50% of you, if you walked into your bank or your credit union tomorrow, can't do it tomorrow because it's Sunday, Monday, you will find out that there is no beneficiary and there's no place for your checking or savings account to go if you were to pass away. And so we run so many checking and savings accounts through the probate process. I always talk about making sure that those are covered, because if you have a financial advisor or if you go through Fidelity or Vanguard, they're very good about pushing you to get beneficiaries. The banks and credit unions are really, really bad at getting you to fill out your beneficiaries. And so two things happen with the banks. Number one, they never ask you when you open up an account whether you want a beneficiary. And number two, there have been so many bank mergers, we've seen them lose a lot of paperwork. And so Monday morning, or the next time you're in your bank, walk in and say, what happens if I pass away? Where's my account going to go? And if they tell you it doesn't have a beneficiary, then get beneficiaries on it right away, because it will go through probate court if you don't have a beneficiary. Okay. All right, ladybird deed seems to be a real hot topic, okay? And you will see in your handout there that I did a summary of the benefits of a ladybird deed in the state of Michigan, okay? It's a one-pager, and it's got a whole bunch of good things to it and no bad things to it, okay? There's nothing really bad about a ladybird deed. But the short version of the ladybird deed is it is a beneficiary designation for real estate. Could be your home, could be your cottage, could be a piece of dirt that you have up north. Okay, you can use a ladybird deed on any of it. And all it says is I own my property while I'm here. I can do whatever I want with it. If I sell it, I sell it. If I mortgage it, I mortgage it. If I lease it, I lease it. I can do whatever I want with it. But if I pass away and I still own it, it goes to my kids, or to my brother, or to whoever I want it to go to. It's got some great benefits, but the biggest benefit in Michigan is that if you ever need long-term care on your home, and you have a ladybird deed, number one, it's not countable for your assets, okay, for Medicaid purposes. And number two, the state of Michigan cannot come back and grab it after you're gone, and if you don't have one, they can. So from a Medicaid standpoint, if you go into a nursing home, you own a house, and that house doesn't have a ladybird on it, then the state of Michigan can later come back and collect against your house. So if you have a loved one in a nursing home, make sure they have a ladybird deed. Otherwise, I have one going on right now where they did not have a ladybird deed. They came in after the fact. The government was making about a $67,000 claim against the house. And there's no way around it.
Speaking of ladybird deed, how about if you have your home in your trust?
If you have your home in a trust, that's the question. It's a great question. A home in a trust is a countable asset under Michigan Medicaid rules. And that means they either force you to sell it or take it out of the trust at the time somebody applies for Medicaid. So we do a ladybird deed that drops into the trust later on. We don't do direct trust deeds anymore. Okay, we used to do it before ladybird deeds, but that was a while ago. So if you have your home in a trust, then you have to decide, do I do a ladybird right now, or do I just set it up so my next in charge can do a ladybird deed if I ever need long-term care? Okay, and we always talk about that with our clients when they come in. Okay. A good question. All right, so beneficiaries, ladybird deed, how other ways we see people getting assets to their loved ones? Joint ownership, okay, putting somebody else's name on your stuff. I say don't do it, okay? Don't do it for a lot of different reasons. But number one, if I add my children's name onto my bank account, who owns my bank account? They do, along with me. And so if, God forbid, they're in a car accident, or they go through marital difficulties, does it affect my bank account? It absolutely does. Okay, I call it colliding your assets with your children's problems when you put their names on stuff, okay? The other thing that people will do on a regular basis is that they'll add their children to their deed. And when you add a child to the deed, you no longer have control of your home. If you want to refinance, they have to sign off. Sometimes their spouse has to sign off. If you want to sell it, I had a case, and it was a horrible case. The husband died. The mother put her son's name on the deed. Does he own the house as much as she does? Mm-hmm. Absolutely. She decided she wanted to move to Florida. Son didn't want her to move. He wouldn't sign off on it. I called him and said, you're not a very good son, right? Why won't you do that? It's your mother's property. And he said, it's my property as much as hers, and there's a specific Michigan Supreme Court case that says he's right. There's no way for mom to get out of that deed without him signing. And so all of what we do when we're doing estate planning is about control and keeping control in your hands. So the ladybird deed is so much better than adding somebody's name to it. The other story I'll tell you has to do with a financial account. And I still remember it, and it was probably 6 years ago, because it still bothers me to this day. So I had a client, it wasn't my client, but it was, family came in after the fact. Mother had 3 bank accounts totaling $364,000. And one of the daughters was close by, so she added that daughter's name to all 3 bank accounts. Then she hand wrote out a will. And the will said, I leave all my bank accounts equally among my 4 children. I love you all the same, please don't fight, which is my first, the first warning, they're gonna fight like cats and dogs, right? When mom knows they're gonna fight. But what happened was mom passed away, daughter is joint on the bank account. Who owns that bank account? Daughter. Daughter owns the bank account. Does the will matter? No, she hand wrote out a will, which would actually be a good will in Michigan. But it didn't work, okay, because daughter's on it. And I called daughter's lawyer and said, we all know what mom wants. And he said, you know what the law is. And we were able to get some settlement, but it wasn't anywhere near what the kids would have got if mom planned the right way. And I tell you this because $364,000 is a lot of money, but it's not that part that bothers me. I still talk to a couple of the family members, and the grandkids don't play together. They don't have Christmas together. They don't have Thanksgiving. And this mother, by not planning the right way, basically destroyed her family for generations. And so if you're going to put somebody else's name on your stuff, just be very, very careful, because it generally results in the kids having a fight, okay? Yes.
Can you, I have just one son, husband passed away, and I had him on my checking and savings account, so it was me and him, okay? And of course, after talking to you, I was to take his name off and put him as beneficiary and give him power of attorney.
Correct.
Right? This way, because if he lives in Minnesota, if he got into an accident and somebody sued him because his name was on my checking and savings account, they could take it.
Correct, and so, again, similar to what I had said earlier, if somebody else's name is on it and they have a problem, that problem connects to your account. And we don't like to see that. And so, with the power of attorney, he has access. So people say, well, I put my son's name or my daughter's name on so they can write checks if I'm incapacitated. Well, they can do that under the power of attorney. Well, I put my son's or daughter's name on it so they'll get it after I'm gone. Well, if they're a beneficiary, they're going to get it after you're gone. So we can do it in much better ways that protects you while you're here, and you don't have to worry about those problems that I'm talking about. And by the way, if you add somebody to your deed, There's also tax issues that I won't get into it, but technically it's not their principal residence, so you might deal with your principal residence exemption. Also, you're doing a lifetime gift because you're putting the name on now, so there's gift tax implications there. So we don't want to have to deal with all those things. So again, we want to do it the right way, okay? All right, top level. Inheritance like a toothpaste. Okay, you ever try to put toothpaste back in the tube? It does not work very well, okay? And we're talking about Beth and Ben. We might have to treat them differently. My wife says about my 3 kids, I love them all the same, I like them differently on different days, right? Beth and Ben, we might have to treat differently, so when might we have to treat our beneficiaries differently? When they're minors. Of course, if you're leaving something to a child or grandchild that's 12 years old, well, we can't leave it to them now because they can't do anything with it because they're not adults. Creditors, we saw a real bad time in Michigan in 2007, 8, and 9, so a lot of the children sometimes that we're dealing with, parents, they have creditors still out there, whether it's credit card companies, whether it's a foreclosure on their home. And if you hand somebody that has creditors an inheritance, what happens? Creditor can grab it, right? So we have to protect it. We've run into some situations where we have sons and daughters in bad marriages. Okay, my daughter is married to a wonderful guy, I love him. But if I left her an inheritance, I wouldn't want him, bless you, I would not want him to take it. Okay, so if you have a son or daughter that's in a rough, rocky marital situation, you might want to protect the inheritance, because if you give it to a son and daughter who ultimately ends up splitting up, they might lose half that inheritance in a split, okay? Substance abuse, okay, it's a very difficult situation that we deal with, but if you have a loved one you're leaving something to and they have substance abuse issues, you're potentially perpetuating that problem by handing them an inheritance, okay? And so you can put things out there over a period of time to help them with any issues they have versus perpetuating a problem. And then probably one of the bigger ones that we deal with on an annual basis is probably 7, 8, 9 times a year we get a call from someone that says, my son inherited something from my mother, so the grandmother, and he's on SSI and Medicaid, and now he's disqualified. So if you have a loved one, grandchild, child, anybody who you're leaving something to that is receiving some sort of governmental benefits, you have to be really careful, otherwise you're going to disqualify them from those governmental benefits. So these, when I talk about these 4 levels of planning, if you don't at least touch base on all of them, then you may be missing a planning opportunity, okay?
I got a question.
Yes.
So, if you exclude one of your kids or grandkids or whatever from a will, can they, I don't know what you call it?
Yeah, so the question is, if you disinherit a child, can you do that in Michigan? The answer is yes, okay? We always have a long discussion before we do that, because it's a very emotional situation most of the time when we're dealing with clients. But you have to have very specific language. So Michigan's got 2 ways you can inherit. One is by receiving an inheritance, and one is by getting what's called allowances. And children are entitled to statutory allowances under Michigan law. So if you don't have the very specific language in there, they might not get an inheritance, but they might get the allowances, which in a child's situation is about $15,000. So it's not a huge amount, but you have to do it the right way. So if you are disqualifying, sometimes you hear somebody saying, just leave them $1. Okay, that's not the right way to do it. Okay, if you leave somebody $1, they're entitled to a copy of your will or your trust. They're entitled to a copy of the accounting, the inventory. They're involved in the entire process after you're gone. So what you do is, if you are going to disinherit it, after carefully considering all the options, you're going to disinherit them, you have a specific provision in there saying, after careful consideration, I failed to provide for my daughter, Sally. And that's all it says, okay, including allowances. There's some other language there. And now they can't argue, it doesn't say because she didn't call me on my birthday, or she didn't visit me enough, or because you can always make an argument about that. It just says, I thought about it, and here's what I did. And it's very straightforward, but you don't leave them $1 or $100 or something like that. Okay? Good question. All right, action step number 2, talk about things early, okay? Tom and Susan, they procrastinated, they put things off too long. They shouldn't have waited as long as they did. But I also had a 92-year-old in my office a few weeks back that said, hey, I think it's about time to put my will together. It probably is. So, as long as you're here, and as long as you can talk and deal with it, then you can deal with it, okay? So it's never too late. Never too late, but the earlier the better. And then, keep everybody involved, okay? And again, my kids are all different. Your kids are all different, whoever you put in charge. Some of them are a little bit controlling, okay? Maybe the one you put in charge. I like to keep everybody involved and be transparent. That doesn't mean you have to tell them every dime that you have or where it is, but keep them involved so that you know, if something happens to me and my wife, my daughter knows she's the next one in charge. So that my boys aren't coming in saying, I didn't know Sarah was gonna be in charge, and now they're angry. But no, they know who's gonna be in charge on the financial side, on the medical side. So be transparent in that regard, so nobody can start an argument later on saying, well, mom and dad never told us, you know, what they wanted, okay? So 5 common mistakes, oh, yes.
Yeah, one question.
Mhm.
I heard that, like, if you pass away and your credit cards, balance on your credit card is automatically paid. Is that right?
So the question is, if you pass away, the balance on your credit card is automatically paid. There's 2 situations where it will get paid. One, if you have a probate estate, because there's a pot of money. One, if you have a trust, because the trust is a shopping cart full of money, and creditors have first shot at your estate or your trust balance to get paid. So they're not automatically paid, but the person you have in charge has an obligation under Michigan law to pay your debts prior to the time they distribute your assets. And that's fair to creditors, right? You know, at least a valid creditor, so.
Glenn, when I was mentioning this presentation to an individual, actually a couple, they said, oh, I don't need that, I've got a will. Listening to you speak, why would you have a will?
So I'll tell you a will plan, so Paul's question was, why would you ever have a will? So 2 things. Number 1, if you have a trust, you also have a will. So those of you with trust, you have what's called a pour-over will. And the pour-over will says everything goes to my trust. So it's like kind of a safety valve in case something ends up outside the trust. Here's when we do a will. We had a woman come in the other day. She had a house, she had a little bit of money in the bank, and she had an IRA. At that point, what we did was she had 1 child. And we pointed the house by Lady Bird deed at her child. We pointed the bank account by beneficiary designation to her child, and we pointed the IRA to her child. Does she need a trust? No. But we do a will as a backup, just in case, if something
You're
happens.
still gonna be faced with probate, possibly.
Possibly, and so the probates that you see out there when we're dealing with it are probates that are unexpected. And so if somebody has an auto accident, you know, rough situation, and that now they're gone, and the driver caused the accident, that all happens in probate court. That has to, because it's not in the trust, it's not anywhere. So the will is gonna pick up kind of loose ends that you don't think about and that you hope never happen, but it's there just in case. So we do have some situations where we plan with a will, but we bypass the will because we don't want to go through probate. So we never ever plan and say, we're gonna give you a will, and by the way, come back and see me, you know, after someone's gone so we can do the probate for you.
And a minimum, from what I understand, the probate cost is $5,000, $5,000.
Yeah, generally speaking, probate, so there's filing fees, and then he said, you know, generally speaking, probate's $5,000. So there's filing fees with the court, there's an inventory fee with the court, and then there's attorney fees. You can get done with a probate in about 6 to 9 months. Usually it's 9 to 12 months if there are no fighting. So, I mean, that's probably pretty accurate, if not more, yeah. Yes?
When we drew ours up with you, we named one son his power of attorney, and our daughter my power of attorney, but then there's another son. And I just assumed they would work together. Maybe they won't, so how do we fix that?
Well, so first of all, you're assuming that both of you would be incapacitated at the same time. So you are each other's power of attorney first. I'm assuming I would have to look at yours because it's been a while.
You're going to look at it.
But, so I would have to look at that specifically. But we get parents all the time, especially probably more on the medical side than the financial side, that said, you know, I want Sally in charge of my medical, either because little Johnny's gonna pull my plug too fast, or little Johnny's gonna keep me around sitting in a chair for 50 years, you know, even if I don't know where I am. And so yeah, we have different people take different kids to do things, and usually it's after discussing it, and you know, we can talk about those details. Thanks, yeah. So 5 mistakes, yes.
I always understood that it was that trust versus will was a amount of assets cut off, that above this you do a trust and below that you don't.
Yeah, so the question is, isn't a trust for so many more assets? And absolutely not. So there's basically a handful of reasons why you might have a trust, okay? Amount of money is one of them, but let's say I have a $10 million IRA and a $10 million life insurance policy, and I have one child. Can I leave my child as a beneficiary? Do I need a trust? Nope, don't need a trust. It's real easy. It's gonna go $20 million. By the way, I don't have that, but if I did, I could leave them directly to one child, and I don't need a trust. So the normal situation, the more assets people have, the more sophisticated their estate is. So they start having properties in Florida or Arizona. They start having you know, different bank accounts, and they're not as consolidated. They have different banks, different financial advisors. So the shopping cart example is a lot easier because everything's in one place. So the more money you have, the more sophisticated your plan is, and the more likely you'll need a trust, but not all the time. The 2 bigger reasons why people need trusts are the types of assets. So I had somebody come in a few weeks back. They have $50,000 in the bank, they have a modest house, and they have a farm in South Dakota. And if they came in without the farm in South Dakota, I would do that plan with Lady Bird deed at one child, and I would do the beneficiary designation on the bank account. But that South Dakota farm is going to go into probate in South Dakota. And now we have a probate in Michigan that you need to open up a probate in South Dakota. And so they don't have very many assets, but the types of assets dictate that they need a trust, okay? And then the other one, and probably the bigger one, is central control. So on my Lady Bird, when Janet asked me about the Lady Bird deed, you can leave it to one child, real easy, straightforward. What if I have 7 kids? Do I want 7 people on my deed after I'm gone? I don't think so, especially when it's them and their spouses that are now have the right to deal with the house. So when you want central control, one of the kids in charge, you need the shopping cart, you need the trust. And then the final reason is the beneficiary protection that I just went through. If you have a son or daughter that has some issues, credit or substance abuse, disability, you can't do that with a beneficiary designation. And so we'll have somebody come in that has, $100,000, and they say, I want it to go to my son, but he's in rehab. And what do I do? Well, we have to have a trust.
Is there any tax benefit with trust versus?
So very similar situation. You're going to pay more for the probate and going through the process, but you get what's called a step-up in basis from a tax, whether you have a will or trust, or a Lady Bird deed, or a beneficiary designation. So those taxes are pretty similar. And so no, there's not a huge tax benefit unless you're over the threshold, and the threshold right now is $13 million per person. So I'm not, you may be, I am not. So.
But that could change,
That could
depending on
change.
who's president.
That's going to come down, so end of 2025, just so you know, January 1st, 2026, the threshold is going to come down from $13 million to about $5 million per person, and it's going to be cost of living up to about $6 million. So a couple will still be able to protect about 12. And so, and by the way, Congress is doing a lot of nothing. They might change it, they might not change it, and we just have to kind of react to what they're doing. It's hard to plan when we don't know exactly what the president or Congress is going to do.
Thanks.
All right, so I want to finish off with 5 common mistakes. One is your digital assets, okay? So your logins, your passwords, your cell phone, code to get into it. we're getting more and more calls now that are basically saying, hey, I can't get into dad's phone, I can't get into mom's computer or email. So make sure that for all of your online accounts, that you can get somebody in there, that your next in charge knows how to get in there. Okay, because it's causing all sorts of practical problems now, because a lot of times we're receiving our monthly statements by email, and when somebody can't get into your email, that becomes a real problem. Okay? Safe deposit boxes. I don't like them, I wouldn't have one, but some people have them. If you have a safe deposit box, this is the one time I say put somebody else's name on it, like a child's name. Because you have to, if you're incapacitated, our power of attorney lets your next in charge get your safe deposit box. But if you're gone, we have to go get a court order if there's nobody else on there. So if you have a safe deposit box, make sure that you have a trusted person on there. Okay? We have subsequent marriages. Okay, this is a big issue that we see. If somebody is in a second marriage situation and they don't have a plan, if a spouse dies, where does everything go? To the spouse, to the surviving spouse. And we see people who accidentally disinherit their children in this way. We had a bad situation where mom and dad owned a cottage, been in the family for 3 generations. Dad passed away. Mom got remarried. Mom needed a new roof on the cottage, so she put second husband's name on the cottage, so they refinanced to get the new roof. Mom died. Cottage is with second husband. Second husband is leaving it to his kids, and I have the kids of the mother in my office saying, I used to fish there with my grandfather. I used to swim there, with my parents, and there's nothing they can do. So if you're in a second marriage situation where you both have kids, you have to plan really, really well. The other situation we see that we don't like to see is when they say, hey, Glenn, I listened to you on Lady Bird Deed, so I have one son, and I left him my house. I'm in my second marriage. My husband lives with me. I left my son my house. Well, wife passes away, and son comes in and evicts her husband out of his house. And that becomes a problem. Okay, so we're trying to balance between taking care of a spouse and taking care of kids from different relationships, and it's really difficult to do. So we have to really plan carefully. Unmarried couples. Okay, so we have long-term boyfriend-girlfriend situations, and we end up with one of them in the hospital. Does the other significant other have a right to go in and talk to the doctors and nurses? Absolutely not. Absolutely not. There's you can read the Girl with the Dragon Tattoo, the book series. The gentleman that wrote that had a long-term girlfriend. He was estranged from his family, and he died, and his family got everything. She got nothing. So if you're in an unmarried situation, you have to plan both on the financial side and on the medical side. Otherwise, your significant other has 0 rights, whether that's the house, whether it's the money, whether it's the medical decisions. Okay? And I already talked about joint accounts. Don't do it. Don't do it. Okay? I have one bonus topic that I threw in because we've been getting some questions about this. You may see these things popping up. Hey, property fraud protection. Hey, home lock. We can do this for $13.99. Life lock for your home protection. Anybody see these things popping up here and there? We have a free service in Livingston County, so you don't have to spend $13.99 a month or whatever they're trying to charge for these things. If you go to propertyfraudalert.com, okay, propertyfraudalert.com, you see that red circle up there. It's going to tell you to pick out a county in the state. You pick out a county in the state, and you either punch in your email address or your phone number, and if anybody ever files something in your name, you will get a notification. And it doesn't cost you. It's paid for by the county. You don't have to pay LifeLock or Home Lock or any of those places to do it for you. Okay? So all you have to do is hop on the computer and do that, and you don't have to worry about, again, they give you notification. Now, my name is uncommon. I guess if your name is John Smith, you're going to get a lot of notifications. And then you'll have to look and see whether it was your property. They don't do it property-based, they do it name-based for some reason. But that's how the other ones work too. So So we've talked about a lot, and I want to make sure that we cover any questions that you have. I did put in, and I think it was actually a Janet's request, on what your next in charge should know. So there's a whole bunch of bullet points about what your next in charge should know, okay? And that's under the, it's under the little ladybird flyer there. And it talks about, you know, making sure that your loved ones have your passwords and they, you know where to look for your logins and different, you know, things that they should know, okay? Is there anything else that I did not cover or that you may not understand fully that you want clarification?
What states have ladybird?
Janet asked me, what states have ladybird deeds? So there's a handful of states out there that have ladybird deeds, and there's other states that actually have similar, like Arizona has what's called a beneficiary deed. It's not a ladybird deed, but it's by statute. So there's, I think between ladybird deeds and beneficiary deeds, there's probably 13 states out there that have it, probably 4 or 5, I believe, that have something called a ladybird deed.
I Googled it before we
Yeah.
came,
Mhm.
and I got Florida, Texas, North Carolina, Vermont, and West Virginia.
So that's 6 in addition to Michigan, and then, again, I can tell you Arizona has a beneficiary deed, and there's a handful of states that actually have passed statutes. Michigan doesn't have a statute, it's just kind of made up by lawyers, these deeds. Some states have said, yeah, you should be able to put a beneficiary on your home, and they have statutes, so like Arizona and a handful of other ones. But we are in Michigan. Florida does have a ladybird deed, it's called an enhanced life estate deed, so a different animal, but they haven't. But they have all sorts of different homestead laws too in Florida that we have here. Yes?
If you have some directive just handwritten, does that need to be, maybe have a witness and notarized?
So if you have directives that are handwritten, are they financial directives or are they medical directives?
Probably financial.
If they're financial directives, then they will not be good unless they're either notarized or witnessed by 2 witnesses. And the dilemma you have, if they're handwritten, I can guarantee you that most banks will not, they just won't, it doesn't fly past their legal department. So if they don't see it in a very specific format, they won't allow it through. So, yeah, you probably don't want to handwrite out like a power of attorney, even though it should be valid, the banks aren't going to accept it. Yes?
That fraud alert, should you get it in each state if you have that, sign up for it?
I'm sorry, does the fraud alert?
Yeah. If you're in multiple states, do you go to?
So some states have it and some states don't. And so I don't know if different, and ours actually in Michigan varies county by county. So some are property fraud alert in Michigan, or in Livingston County, and then Oakland County has a totally different one. And so you can Google property fraud protection, whatever county you are in, whatever state, and then.
But if you have multiple properties in different states, you should do it twice?
Right, you're gonna have to do it in each county.
Okay.
And normally what we do is, if you go to like Livingston County Register of Deeds, it's one of the pop-ups there, it says, do you want to protect your property? And so I would just go to the Register of Deeds for each county that you have property in, and then you should be good. Yes?
With all the COVID restrictions and all the lockdowns that they had, like in hospitals, and you have this HIPAA law and everything else, how would that, what was learned from all this COVID stuff?
So-
With those laws and how they would apply and your rights?
Yeah, really good question. So what was learned with all this COVID stuff regarding HIPAA and these things? Really difficult. I have a photograph of a client. The husband had the wife on his shoulders, and she was looking in the nursing home room of her mother because they wouldn't let her in to talk to her mother, and it's heartbreaking. And did we learn anything? We might have learned something. The question is, did the government learn anything? And I can't answer that question. I wrote a blog at the time that we were pushing COVID positive people into nursing homes at the beginning, and I wrote a blog at that point that said this is not a good idea. These are our most vulnerable seniors, and we're pushing the COVID people in. So did we learn anything? I don't know. I think we all learned something, but when they had the lockdowns at the nursing homes, we fought with nursing homes to try to get people in, and it was really hard. And because the law basically said the nursing homes basically could shut out anybody they wanted to shut out. And whether you're tested, whether you're not tested, and so I think, again, as a public, we've learned a lot. I'm just not sure if it happened again in the same way, would the government deal with it in the same way or not? I don't have a lot of faith that it would be a lot better.
Are there any like new laws or something that might go into effect to help protect?
The only thing that we got, are there any new laws? And they're not protective laws, but along the way, I think they determined that visitation. So we had, again, I can't tell you how many clients that died alone, without their family being able to visit. And whether they died of loneliness or some medical condition or whatever, I think we've learned that you have to allow that social interaction regardless of what we have going on there from a legal or a medical standpoint. You have to figure out a way to let people socialize.
And what about the responsibilities of the hospital? From what I heard, that if COVID was put on there, then, they really aren't, in trouble.
Yeah, and so there basically is a law out there that said during the public emergency, which lasted all the way through COVID plus some, that if someone died in the hospitals are not responsible. And that, again, that's the legislature, that's the government putting those laws in place. And, the hospital, of course, lobbied for these, saying, look, we can't treat all these people and then worry about getting sued later because things went wrong, but now they can't be sued. You cannot be sued for any COVID-related, sickness or death if you were in the hospital.
This is just a question I'm thinking of. If you have someone in a nursing home and this happens, okay, do you have the right to go in and take them out if you're the one who put them in?
Yeah, so absolutely. So do you have the right to take somebody out of the nursing home? So two things. If they have their capacity, you always have the right to leave wherever you are. If you don't have your capacity and you have the patient advocate designation, you absolutely have the right to remove somebody and make placement decisions, and they cannot stop you. We did have a lot of people move out of long-term care places during COVID, and so yes, you can. And we did have to fight a few times to get people out, but the bottom line is you have to sign a release going out the door saying, because they're saying we don't recommend that you leave, so sign this release. If something happens, they're not responsible. But yeah, we had a lot of people go home, during COVID.
I was just thinking about that, because both of my parents my dad had Alzheimer's, and he was in a nursing home, but I certainly wouldn't have wanted him there alone. I was with both of my parents when they passed, but when they were saying people couldn't go in, my parents were already gone, so.
You could take somebody out, and the only dilemma with taking somebody out is then they had a 30-day quarantine or 2-week quarantine when you brought them back in, if you brought them back in. And again, but if you're going to take them out, you absolutely can. Yes?
I was just wondering, other than what you've already said, do you have any other advice for how to deal with a lot of children? I think I know what to do with one.
So the question is, how do I deal with a lot of children? So can I ask how many is a lot?
Well, for us it's 7.
7, that's a lot. So I would not have beneficiary designations in a will. I would have a trust if you have 7 children, because basically you have no way to have any one of them in control. So let's use a real simple example. I have a house and $700,000. The house is Lady Bird deeded to all 7 of them, and I have each of them as a 1/7 beneficiary on my account, so they each get $100,000 on my passing plus a 7th of the house. When the house goes up for sale, all 7 of them have to decide who to list it with and how much to sell it for and whether to accept an offer. Sometimes their spouses will be involved. Okay, and if you deal with spouses, they're stirring the pot sometimes, okay?
That's what I'm scared.
And then somebody's got to pay for your final expenses, for your funeral, for example. So all of your kids have $100,000. One of them steps up and pays and goes to the other 6 and say, hey, can you reimburse me for your portion? And one of them says no. now it becomes a problem. So if you have everything in the shopping cart, then everything can be paid out of the shopping cart first, and then it's doled out 7 different ways with one person in charge. So a trust, when you have a lot of kids, a trust becomes much more, much more advantageous. Yes?
For the veterans benefit for spouse?
Yes.
Surviving spouse. Is that wartime or is that combat?
So is the veterans benefit wartime or combat? It's wartime. So you could be peeling potatoes in Texas, and you are in during that wartime, you are covered. Okay? So you do not have to be boots on the ground. Actually, from 1961 to 64 or 65 in Vietnam, there is you had to be boots on the ground in Vietnam. Otherwise than that, there's no combat requirement. Okay. All right, we talked about a lot of things. I appreciate your patience for hanging in there. I'm going to be around for a little bit. I did promise, Janet, when we talked about this, if any of you want your plan reviewed, feel free to call the office. You can drop it off. I'll review it for you. I'll be glad to do that. But other than that, I'll be around if you have more questions. I know some of these tend to be a little personal, and so you don't want to raise your hand to talk about them, but I'll be around for a little bit if you want to talk. Okay? Thanks so much.